Huh. So my screen is visible now.
Yes, it's visible.
Okay, so let us start from March. Okay, March 2020, and Feb, and then Jan. So, no, of course, on right hand side, I think left, if you can recall, it was April. Okay, that EIA, all those things. So now moving forward, March. Okay, starting with March 2020. So SC quashes RBI ban on banking services to cryptocurrency dealers. So I think this was that Supreme Court judgment which set aside RBI's ban on cryptocurrency. Okay, last year. So in a significant judgment, the Supreme Court lifted the curbs imposed by RBI on regulated entities such as banks and NBFCs from dealing with virtual currencies and providing services to crypto businesses. So earlier, I think RBI had banned it. Now Supreme Court has lifted the curbs which was imposed by RBI. So a bench comprising so and so, which prevented regulated entities from providing banking services to those engaged in trading or facilitating the trading in virtual currencies, was liable to be set aside on the ground of proportionality. So, this was the ground which they used to set aside the RBI ban, okay, ground of proportionality. So, this is it was, I think, a major news back then also. Okay, so maybe Vision had covered this in last year's PT, maybe. Okay,
Okay.
so we'll move forward. This is one major item. So next is appointment secured on the basis of fraudulent caste certificate is void ab initio. I think void ab initio, I think, is from the beginning itself it is void.
From the
Hmm.
initial
Yeah,
null and void.
correct. So appointment secured on the basis of fraudulent caste certificate is void. Okay. So SC observed that an appointment secured on the basis of fraudulent caste certificate is void ab initio, and government resolutions and circulation and circulars cannot protect such appointees. So the bench of so and so was considering an appeal against Bombay High Court. Okay. So this was about this judgment. I think much generally we know this line of thought. So we'll move forward. The next is farmer entering into buyback transaction with seed company is a consumer. Oh, so farmer who has entered into a buyback transaction with the seed company is a consumer. This is what Supreme Court has told. Okay. So Supreme Court has held that a farmer is a consumer. Okay, because he's consuming I think the seeds maybe, right? A consumer for the purpose of filing complaints. Oh, under Consumer Protection Act, when he has entered into a buyback agreement. So under this Consumer Protection Act, if farmer has entered into some agreement with any conglomerate or company, so he's a consumer. That's all. So if at all something comes up like who is a consumer, maybe they'll ask now who of the following is a consumer, one, two, three, four, something. So
Hmm.
if farmer is given, just ensure that it is farmer also. Okay. So that's about it. Maybe
I,
we
I
can.
hope you're recording it now. I think you forgot.
No, no, no. Yeah, yeah, it is going on. Okay.
Acha.
Yeah. So otherwise we'll forget everything. That's also okay. So yeah, for this I think farmer we must know is a consumer, and Consumer Protection Act also we must revise. Okay. Moving forward, this again is an important judgment. Both I think prelims and mains. So sexual harassment at workplace is an affront to women's fundamental rights. Okay, so this we know, but already Supreme Court is trying to reiterate the position. The sexual harassment at workplace is an affront to the fundamental rights of a woman. The SC remarked while upholding a High Court judgment that quashed the transfer of a woman bank employee. Okay, so nothing much here. No, this this act we must try to revise, I guess. Okay, Sexual Harassment at Workplace Act. Okay, in totality, nothing much here, and we can use this quote always. I think it's enough at workplace is an affront to women's fundamental rights. We can use such thing.
Hmm.
So moving forward, so SC directs Navy to grant permanent commission for serving women SSC officers. I think as we know that even from last year it was in news, no, granting permanent commission to women in army, and also this was in navy, and now recently NDA exam, women being allowed to take it.
Uh,
So all
agree.
these come under one broad bucket. So in a landmark verdict on gender equality, so SE on Tuesday held that serving women SSC officers in Indian Navy, so they were entitled to a permanent commission with their male counterparts. Okay, so this we must know for Navy also. They've extended this. A division bench comprising so and so judges pronounced the verdict in the case Union of India versus so and so. It may be noted that the same bench had on February 17 delivered a judgment favoring extension. This is the same. No, that was the same thing. Okay, they've extended. So extension of permanent commission for women in army was done in February, and on the back of it in March they have done it for navy also. Okay, so again progressive line of thought they're taking. uh, First army and then navy happened, and now NDA, right? So this is a progressive thing which is going on. Okay, the next is Nirbhaya case. SC dismisses final plea of convicts to stay execution after past midnight hearing. Yeah, so this I think we all remember. So hours before the scheduled extension, the convicts in Nirbhaya case knocked the doors of Supreme Court past midnight, hoping for a last-minute judicial intervention to extend their lives. But the last-ditch effort of the convicts met with no success, as the bench comprising mm, Justice R. Banumati, Ashok Bhushan, A.S. Bopanna dismissed the plea after special sitting was commenced at 2:45 a.m. No such a was a urgency, and at about 3:30 a.m. the bench dictated the order, and they dismissed the writ petition filed by them, okay, challenging the rejection of the mercy petition of the. So see, ultimately, if you see this circle, now they challenged, they went to president, okay. President also dismissed their mercy petition, and after that they challenged that mercy petition to Supreme Court.
Okay,
So that
I think
huh yeah, so you're telling something.
huh, that is allowed, but the court rejected, I guess. No?
Yeah.
Curative petition is the last, I think, resort.
Huh.
Yeah.
So
Okay.
they rejected it, and they were ultimately hanged on the same day at 5:30 a.m. Okay, so that's when this entire episode came to an end. So SC dismissed the final plea. And from the polity perspective, also, if you can see that the president's mercy petition can be challenged, right? This line of thought we must be aware that it can be challenged, but it's up to Supreme Court to again uh, accept or reject it. Okay. So moving forward, this is the last thing from March. So Supreme Court directs states, union territories to consider granting parole to prisoners in lesser offences to decongest prisons. So as we know that the congestion of prisons uh, and maybe the under trials, so more than 67% being under trials, has led to a situation where prisons are congestion in the country. So that is why to decongest that prisons, Supreme Court is directing states authorities to grant parole to prisoners who are in lesser offences. Okay, so one step towards decongesting the prisons. So to, and this also has a context of COVID also, because of over congestion density thing might lead to infection. So, to avoid overcrowding in prisons in the wake of COVID pandemic, Supreme Court directed all states and UTs to set up high-level committees to determine the class of prisoners who could be released on parole for 4 to 6 weeks. So maybe that term parole, no, maybe if it has some specific connotation, we must try to revise. But does it have any specific thing? No, no.
No, I don't think so. I
So
think
some,
that.
it is just the release of the prisoners. That's all I think. So we can just look up later. So a bench headed by Chief Justice observed that prisoners convicted of or charged with offences having a jail term of up to 7 years. Okay, this is the case they're taking, that up to 7 years if they have such a jail term, they could be given parole to decongest the jails. It so happens that in our system, many would have a jail term of maybe some years, and because of the slow pace of judicial dispensation, they would have exceeded the term already. Right, we have seen in many judgments also. So they can release them because they've already served the term in that context. Okay, so this maybe in the context of prison reforms, if it comes up now, we can cite this as an example. But apart from that, I don't think This no, might come up anywhere. Okay, so this was March 2020. So we'll move next to Feb 2020. Okay, so I think left or right, I'm not sure. Okay, maybe this one. So we'll start with left and finish with right. Okay, so Feb is Feb, I think, and then right one maybe Jan. So I'm starting with Feb. Okay, so SE upholds the validity of SCST Amendment Act. So I think this entire episode of SC, the government amended this SCST Act, and then Supreme Court upholding it again. That happened. Okay, so SC has upheld the constitutional validity of the SCST Act, which was enacted to nullify its old judgment. Correct. It was enacted to nullify the effects of the earlier judgment which he had given. So the Supreme Court's earlier judgment had diluted the act, and then Parliament brought an amendment to the act, and then Supreme Court upheld the amendment. So this is the entire story of it. Okay, so nothing much here. You must just try to revise the latest act. That's all. Whatever it has amended, no, that we must try to revise. I think. Okay, so
Okay.
we'll move forward. So next is child. Just see this line, one-liners. I think a fraternity assures true equality. Article 15, 17, and 24 seek to achieve this ideal. Okay, justice has told in this verdict. This I'll repeat again. I think it seems important. So fraternity assures true equality. Okay, I don't know if some MCQ comes up. Which of the following assures true equality? I'm not certain.
Uh,
So,
they're asking such questions.
right. So,
Answer.
fraternity assures true equality. So in that liberty, equality, and fraternity, that I think fraternity is the one which is assure true equality, because I think it's about brotherhood, right? So once people accept each other, more tolerant, more than tolerant, it's about acceptance. How they are, that is maybe true equality. So that's why Article 15, 17, and 24. 15 is we know, 17 no untouchability, and 24. Uh,
For children,
children, right?
child.
So they seek to achieve this ideal. Okay, this is what it has been told in the judgment. Okay, so important. You can remember this one. So moving to the next one, child in conflict with law. Okay, just a minute. Child in conflict with law cannot be kept in jail or police lockup under any circumstance. Exactly. So, child in conflict with law cannot be kept in jail. Keeping children in jail and in lockup creates such an huge psychological damage. So we make it clear that the juvenile justice boards, okay, the juvenile justice board are not meant to be silent spectators and pass orders only when the matter comes before them. They can take note of the factual situation if it comes to the knowledge of the juvenile justice board, that a child has been detained in prison or lockup. So it is telling that these JJBs can take up the issue. That if a child has been detained in prison or lockup, you can take up this issue, right? If they come to know such fact, it is a duty. Okay, it is a duty of juvenile justice board to ensure that child is immediately granted bail or sent to an observation home or a place of safety. So that's a board function, core duty, I think, of juvenile justice board. The act cannot be flouted by anybody, least of all the police. The court observed. I think this becomes maybe if you remember, na, maybe 2 3 months back, I think juvenile justice board also had come up in our discussion. Um, Juvenile Justice
That is.
Act also.
We had that PT wala na,
हाँ
age wala.
हाँ हाँ right. I think even in one of the earlier judgments also somewhere it had come up.
We had.
So in this context, maybe revision of Juvenile Justice Act again becomes important, and specifically Juvenile Justice Boards, their duty, something from the constitution angle. Uh, so that thing we can revise. Okay? That becomes important for from this case perspective. So we'll move on. SC directs political parties to publish criminal antecedents of candidates in Lok Sabha and Assembly polls. I think this was a very important step, but this has not been followed. Let me read this. Supreme Court directed political parties to publish criminal antecedents of candidates in Lok Sabha and polls. Yes, they said that because of rising criminalization of politics, taking note of the alarming rise of criminalization of politics, As we know now, it is 43% in the current Lok Sabha. SC directed that all political parties to publish details of criminal antecedents of their websites in the Lok Sabha and within 48 hours of the selection of the candidate, or within 2 weeks of the nomination. See, because of this, they told that whenever you select a candidate, maybe you're selecting some person, you must tell within 48 hours of selecting him that why you have selected this person despite he having such a criminal background. Okay, this was what Supreme Court had told them, but they have not done this. Okay, and recently, just I think 1 or 2 weeks back, another judgment had come. Okay, I think that will discuss uh, in August. Okay, August, when we discuss that, will discuss. I'm just telling because I had read this. So they told they put hefty fines on political parties across all political parties. They have put fine because they have not followed this judgment which we are discussing. Okay, this is the overall story which is running.
So
So,
it becomes important. The time limit 48 hours selection say and 2 weeks of nomination, and there is also a provision of fines.
huh.
Okay.
Okay.
Yes.
So what I'm trying to do, this judgment is connected to the just recent judgment which has happened. Okay, just 1 or 2 weeks back, which we'll discuss when we take up August. Okay, it's a chain. This judgment was not followed by political
Okay.
parties. They didn't publish it. Okay, and obviously for political reasons they didn't publish it. So Supreme Court came down heavily on them, saying that why didn't you publish, and they imposed fine on them also for contempt something. Okay, since they didn't follow this order. So I think we must quickly finish off. August also post this so that we have some continuity. Okay, just remember this: the information should be published in local newspapers and uploaded on the official websites. Okay, you can just see this local newspaper upload on their official websites and even the social media handles also. And you know that what they publish, all goody things they publish. They would obviously resist from publishing such information. So information should contain the nature of the crime. See, they should publish what is the nature of crime and at which stage of trial investigation it is there. So such was the detailed direction given by Supreme Court, but they didn't follow this. Okay, they didn't.
And we have to remember it is and like in every like even in newspaper, also on website and also on social media handles. Like
Exactly.
they cannot choose one source. Okay.
Exactly. So they
Okay.
didn't do this. Okay, this is the thing they didn't do, and the Supreme Court came down heavily on them just 1 or 2, I think 10 to 15 days before. Okay, so that we'll discuss in August. So just remember for now this thing. Okay, important one in the context of criminalization of politics. Moving forward, so notion that women are weaker sex is constitutionally flawed. So SC calls for change in mindset. Exactly. So this is what uh, I think when the case of allowing entry for women into the permanent commission of army came up, this was the argument from the center. Center was trying to tell that they were giving reasons why you are keeping women out when the Supreme Court questioned. What I remember, no, center was trying to tell that no, women form a weaker sex, so they we are keeping them out. Okay, so this Supreme Court is trying to tell that no, this argument that to consider them as weaker sex is flawed, and because Constitution also talks about equality and other things, this is fundamentally flawed, and it requires a change in mindset because we are living in a patriarchal society. So this is the notion we have. Okay, so notion that women are weaker sex and may not undertake tasks that are too arduous for them, are constitutionally flawed. Okay, so this is flawed. Observed Supreme Court in its judgment, which had which held that the absolute exclusion of women from the from command appointments in army is illegal, right? So that was the context, and then the bench comprising so and so judges observed that to cast aspersion on their abilities on the ground of gender. Okay, so you're trying to demean them only because of their gender is an affront not only on their dignity as women, but to the dignity of members of army. Okay, that is men and women uh, who serve as equal citizens in a common mission, right? So this was the argument given by center. But what I've been reading about this in editorials and all those things are, see, this argument whatever giving that women are weaker sex can be also negated if you give instances from the history. Like for example, in history we have innumerable examples of maybe Rani Lakshmi Bai or the Kiturani Chanamma, right? And even the
Rani Gadin Liu of Manipur.
exactly. And even Subhash Chandra Bose, went to the extent of giving women regiment, right? Lakshmi Sehgal.
Correct.
So all these instances in the history also show that women have been affront in leading when it comes to even such revolts also. So this notion that women are weaker sex is constitutionally flawed and having some social, that social patriarchy thing. Okay, so in that also you can give such examples. So this is about this thing. Moving forward, judicial officers cannot seek up- uh, direct recruitment to the post of district judges. Okay, so I think what was happening is, wait, let me read this completely. So judicial officers cannot seek direct recruitment to the post of district judges against quota for advocates. So I think there were some instances where some people were being directly appointed to district judges. Okay, but that was not allowed. I think. Okay, that is the context. The Supreme Court held that civil judges who are not eligible to seek direct recruitment to the post of district judges in bar quota. Okay, just repeat this. So, Supreme Court held that civil judges are not eligible to seek direct recruitment to the post of district judges in bar quota. Okay.
They were utilizing the quota of advocates, I
Ha
guess.
ha.
They
Correct.
have.
Correct. Right. So thus it's not eligible. So see the article also which has come up. Eligibility under 233.2. Okay. 233.2 is a article of the Constitution. This stipulates that it requires 7 years of continuous practice. We know, no, 7 years they need uh, advocates to be appointed as I think judges. So only practicing candidates can avail the quota. It is exclusively for them. Okay, it is exclusively available for those practicing candidates and for 7 years if they've done. So Justice Arun Mishra dictating the order said Article 233.2 nowhere provides eligibility of in-service candidates for consideration of a district judge concerning a post requiring 7 years practice as an advocate or a pleader. I think this becomes important. Okay, they might ask the qualifications and such things to be appointed as a district judge, which you must revise from the polity section. Okay, Lakshmikant. So 233 is also there, 7 years requirement. Okay, and they cannot be up direct. This civil judges they cannot seek this quota. Okay, these dimensions we must know. A requirement of 7 years experience for advocate or pleader is qualified with a rider that he should not be in service in the union. Exactly. See, these civil judges now they're in service in the government. Okay, they'll be holding 1 hour at a small post. So this 7 years is purely for advocates, right? Who are doing 7 years of service. For them, this is reserved. You being part of government or part of some lower judiciary, you cannot claim this. This is the line of thought. I think. Broadly, you got it right.
Huh.
Okay, so 233 is important. Revise that, and then this criteria for to be appointed as a district judge. This you must revise. So moving forward, this is the last judgment of February. So boycott of courts. Okay, boycott of courts can't be justified as freedom of speech and expression. Okay, SC on lawyer strike. So lawyers were boycotting the courts, and this can't be justified as freedom of speech and expression. Is what Supreme Court is trying to say. Supreme Court came down heavily on advocates in the districts of Dehradun, Haridwar, and Udham Singh Nagar in the state of Uttarakhand for holding strikes by boycotting courts. Yeah, these lawyers were doing strike and they're boycotting courts. The SC noted that despite direction in precedent, such as in the earlier judgment, okay, this was earlier thing, ex Captain Harish Uppal versus Union of India, lawyer strikes were happening. Okay, so lawyers I think cannot do such a strike, uh, maybe because of public, because
Maybe it is also considered as a public utility service.
correct, because no justice delivery is such a thing that which impacts a larger society, right? So in this backdrop, suo moto notices were issued to the Bar Council of India and state bar councils to suggest further course of action and to give concrete suggestion to deal with the problem of strikes slash abstaining the law work by lawyers. So lawyers cannot do this. I think they have done this. So this also we must be aware that that right to strike, who can do and who cannot do. Maybe that dimension. I think you posted shared one MCQ. I think long back on the right to strike thing.
Ha ha.
So
Yeah,
that
you explained it, no? It's an implicit right, no?
no, no, right to protest. I think not right to strike.
Ha, acha, ha, that was right to protest.
Huh.
There was a question regarding this also.
So just have to look up on the right to strike. Obviously, it's not a fundamental right, but who can do this and who cannot do this also, maybe that dimension. Uh, Obviously, from this we are getting an inference that lawyers cannot do right to strike, something like that, and maybe, as you said, some public utility involved. Okay, so let us get that clarity that who can. I think since it's not a fundamental right, who can do or who cannot do, or maybe who cannot do at all right to strike, like doctors or
Oh,
something. No?
ha, the LPG and people,
Huh,
no?
huh.
Like
Correct. Electricity.
doctors,
Huh, correct.
electricity wale, they cannot do.
So that may be one list if you can see that would do justice to this topic. So this was about February. Quickly we'll move to Jan 2020. I think only two judgments are there. Okay, so this I think already was a mains question, maybe inspired. So speaker should decide on disqualification within 3 months. So if you see earlier, anti-defection law does not have any time limit. That's the biggest drawback of anti-defection law. So Supreme Court in the judgment said that speaker should decide on disqualification within 3 months, and impartial tribunal needed under 10 schedule. This was its opinion, because speaker generally there's an impression that he is non-partisan. I mean, he's partisan. Right? This is the impression which speaker gives through his orders. So that is why it is telling that you must please dispose your disqualification within 3 months, and you must act as an impartial tribunal. This was inference. So, in a notable judgment, Supreme Court held that Speaker of Legislative Assembly should decide a petition seeking disqualification under the 10th schedule of the Constitution within the period of 3 months. So, 3 months has come up. If a question comes up like under anti-defection law, a time limit is given, then this is false. Okay, that is false because
Ha, because,
under law it's not there.
yes.
In the absence of this thing, highlighting the importance of taking a decision within a reasonable time. Yeah, because they have to take under reasonable time, because otherwise, all this horse trading will happen. The speaker, in acting as a tribunal, okay, see, speaker must act as a tribunal, like he must act as an independent judge under a 10 schedule, is bound to decide disqualification petitions within a reasonable period. A period of 3 months from the date on which the petition is filed is the outer limit within which disqualification petitions filed before the speaker must be decided. Okay, this is what it is telling. If the constitutional objective of disqualifying persons who have infracted the 10 schedule is other two. Okay, just you're telling that, no, same thing. This was held by a bench comprising, okay, so and so judges in a case related to that defection which is happened in Manipur Assembly. This speaker now he never decides. Okay, he just keeps it, but he does it based on circumstances, because he has that flexibility. Sometimes when the party tells, he immediately disqualifies 1 day later. Sometimes he doesn't disqualify. So that is the thing.
Actually, it's a gray area, no? So
Yeah.
that is why a lot of Supreme Court judgments are coming up.
Correct, correct. Okay. So this maybe for mains, and maybe anti-defection law we must revise from prelims. Okay. So moving forward, the last one from Jan. SC issues a slew of directions to curb air pollution in Delhi. Okay. Uh-huh. So they've given a slew of directions to curb air pollution in Delhi. MC Mehta was Union of India. So SC passed a slew of directions to address the protracted problem of air pollution in Delhi. The bench of Justice Arun Mishra and Deepak Gupta has passed several directions dealing right from the problem of stubble burning to vehicular emission to construction dust. So all these three problems are there in Delhi: stubble burning, vehicular emission, construction dust. So in this regard, the Municipal Corporation of Delhi and governments of Haryana, Rajasthan, UP have decided, no, have been asked to file an action taken report within 3 weeks along with compliance report of previous directions. Okay, so nothing much. No, they have given direction
Hmm.
that no control air pollution in Delhi. same old issue of air pollution, maybe from mains
Right.
only. Okay. So we have completed 2020 Jan
Jan, huh?
to June.
March.
No, no. Overall, I'm talking. Okay. 2020 Jan till July 2021.
1.
So
August is left
August
only.
is left out. Quickly, we'll take up August. Today is 28th. Okay. So maybe 31st, maybe we can take up. Okay. I feel okay. 31st would be,
Uh,
or 1st September. We are on that
huh.
date. We'll try to finish August. So that would
Hmm.
put entire thing no on schedule. And if we revise these things in line, I think quality uh, should be taken care.
These will be
Hmm.
these will be really helpful, no?
Most
All the
pri- mo-
important,
most priority topics for revision. It would be right.
right.
Okay, fine. So we'll end it here for today. Okay.
Okay.
Okay. Bye. Thank
Thank you.
you.
Bye. Thank you so much. Bye.